Hey everyone, Harry here to talk about a breakthrough in the overall panoply of lawsuits trying to keep Elon Musk and his boys at DOGE from accessing private records of people. So we have a judge who has in fact entered a temporary restraining order and has taken it a step further than the other courts have done. What other courts have mainly said is yes, by the presidential orders, these different agencies have provided the information to Musk, but there's no irreparable injury until and unless the Musk guys actually disseminate it. That's a problem because the remedy, there's a remedy if they disseminate it, but it's just money damages or potentially a penalty against the people who do it under the Privacy Act. But once the barn door is open and the information has been given out, that doesn't do very much. Now, to date, several judges, including good judges whom you're aware of, Judge Chutkan, Judge Moss on the D.C. District Court, have said we need more information in order to find standing for the plaintiffs. Here, however, Judge Boardman, Deborah Boardman, a Biden administration appointee, takes it a step further, and it seems sensible to me given the new factual scenario of all this DOGE stuff. Okay, it's a lawsuit against the Secretary of Education and the Office of Personnel Management by people with all this student loan information housed in the federal government. And the orders have clearly given some of the Musk squad that information. Now, the normal kind of finesse or strategy of the Trump team is to say those guys have been designated. DOGE came in with their cadre of, young Turks, and we've made them employees of the agency in question. And so really we've put this guy in Department of Education. He's just seeing what the Department of Education already sees. Or the alternatively, even if they think about in terms of DOGE, disclosure within the government, even to someone who's not authorized, hasn't to date been considered a sufficient injury. But we haven't had this context before, and the analysis here that really matters is that, look, we have cases where there have been arguments by the government that a certain employee not on the sort of authorized list should receive a piece of information for a particular need to know. The regs and law say you can't have it, you can't disseminate it to anyone, but there is an exception for government people who have a need to know. And what the judge here says is, this is a whole new context because we're talking about literally millions of records. And she marches through the orders given for the Department of Education and Office of Personnel Management. She says, you know what? I don't see a need to know here. And that, therefore, I think that the plaintiffs are going to win on the merits. I'll get back to that in a moment. But the basic idea, she talks about DOGE and its stripping fraud and finding efficiency and the things they say they're doing, though don't really seem to be doing, and analyzed it pretty carefully to say, I don't think you have a need to know the personal data of all these millions of student borrowers to do that. Likewise, Office of Personnel Management, you're in general have these, vague marching orders to effectuate Trump priorities and the like. You don't have a need to know about all this individual information. And it's that Judge Boardman uses to take the next step that other courts haven't taken. And now to put it in the context of a temporary restraining order, she issues one, and it's issued to the Treasury Department and OPM saying, do not give the DOGE folks any information. You are not allowed to under the law unless they have a need to know. And I don't think they have a need to know. And that is the first step. Remember, all these things come about in terms of a request for an injunction, and you have to show special things in order to get that. You have to show you're probably going to win. You have to show there's irreparable injury. So as to that, the judge says, and it really is the case, it's the kind of, nut that other courts haven't cracked yet, which is once the information has been disseminated, it's irreparable. You can give money, but that's and actually that could be part of the fight going forward. Is that count as an irreparable injury if, in fact, as I think is probably likely, the administration appeals Boardman's order to the Court of Appeals. And then she says the balance of equities are with the plaintiffs. There's no real hardship to the government, but there could be to the defendants. She also said initially that there is standing. It's an important point that some of the courts have been a little shy about, but it's just a fact that shouldn't really make anyone have pause. Invasion of privacy is an injury for purposes of standing. So to take it just sort of through her analysis, we have many different plaintiffs, individuals, organizational, etc., but they're alleging an injury, invasion of privacy. That's a real injury. And the DOGE folks who have this don't have a need to know. The precedents that apply to one piece of information don't apply to millions and millions. And therefore, the plaintiffs are probably going to win. The equities are with them, etc. So the innovation here, I think the standing analysis ought to stand. I don't see the Fourth Circuit or, unless the Supreme Court really wants to pull out the rug from under established standing injury. I don't think they will. The question's going to be whether the law that gives a pass or acknowledges a need to know on the part of individual government officials for specific tasks or duties can be applied in this blanket way to the millions and millions of records that the Department of Education and OPM have provided access to the DOGE folks in order to get. And that really strikes me as the core point here. Anyway, they're doing, they're trying something new and tricky, and that maybe comes with the territory. The more we get technological or bring AI to bear or whatever, you have these vast disclosures. And that's what the law really ought to confront, is the legal doctrines that were fashioned for very fine-grained individual piece of information. Can they be applied to the whole kit and caboodle of the stuff that DOGE is now getting? So a strong opinion by Judge Boardman saying they can't be, and setting it now for hearing, saying, stop right now, and we'll decide in a regular way whether there is, whether this is unlawful. Under the APA, the Administrative Procedures Act, which tells agencies they can't do things arbitrarily and capriciously, and it's there that the need to know exception basically comes in, and that the judge has rejected it. So that's going to stand now until they appeal. Will they appeal right now? They can. take it to the Court of Appeals, and it'll be on this notion that I've sort of spelled out of whether there's a need to know, and then even to the Supreme Court. Or they could go and try this on the merits and then try to take their appellate remedies. As I say, this crowd is very sort of slap happy about doing emergency stuff. I think that is what will happen here, but now things are set up. So a solid opinion striking down for the first time in a full-bodied way DOGE access, giving the legal rationale, distinguishing the previous case law, and now serving it up for, I think, what the resolution is really going to be at the Court of Appeals level. Okay, so there you have it. A first-time expansion in the principles and a solid slapdown of not just DOGE, but Treasury and OPM for giving information to DOGE, and probably, almost certainly, a battle on appeal. Court of Appeals, Supreme Court, set up to conclusively decide the issue. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.